videos? I mean,
Yeah.
on Contra S YouTube or
Yes, on Contrast YouTube.
okay, because I see there's only Jiazhen in our room, our colleague from TAEDP. But I
Yes.
think maybe
Yeah, you can share. You
Yes.
can share the
maybe
meeting link to the YouTube.
Yes. I
yeah, maybe
just share the link to Jiazhen.
okay. And I think it's a good chance to have all of us gather here. So maybe we need to like promote the channel or like to share the information of, I mean, or the content of our panel later, or yeah, just okay. Contra S, the YouTube channel. Okay, Hans, could you like share us the YouTube channel of Contra S later in the chat room, or
I share the link on the chat room.
okay, thank you so much, Hans. Aviani, I want to make sure, so we can call you fans too, or
Please call me Funny.
okay, funny.
Yeah.
Cool. Okay, so maybe we can start now.
Yeah,
Okay,
sure.
so yeah, Fanny and Yixiang, which of you want to be the first?
It's up to you, but if you let me first, I will. I already yeah.
Ready?
Wait.
Okay, so maybe Fanny, you can be the first. Okay, but let me have a brief introduction of two like speaker. Okay, so Fanny is from Contra S, and the full name of Contra S is called the Commission for Disappeared and Victims of Violence, and it is an NGO based in Indonesia. And Yixiang is from, wait a moment, the full name of
TAEDP.
Taiwan Association for Human Rights, and it has been like run and caring about human rights in Taiwan for more than 40 years. Yeah, so Yixiang will share the death penalties situation in Taiwan with us. So okay, and myself, I am the member of TAEDP2. The full name of our organization is called Taiwan Alliance to End Death Penalty, but myself also working for Tibetan movements in Taiwan. Okay, so let's welcome Fanny to share her talk.
Sorry, Jasmine. I think it's there's an I'm mistaken because I'm from Indonesian Center for Law and Policy Studies, and from the contrast we have Hans. He already checked. Maybe
Yeah,
Hans,
sorry.
your real life first.
Yes, because like in your email groups, I cannot like
Okay,
identify people's. Yeah, but yeah, we have Hans at the same time. So Hans is from Contra S. Maybe you guys can share more about your organization. I'm so sorry.
It's okay.
Yeah, Fanny can start, and I may have some additions after she's talking. Thank you.
Okay. Thank you. Great. Thank you so much, Jasmine, for introducing me. And I would like to say good afternoon for all participants and all distinguished speakers in this room. I'm beyond happy to be in this panel and super excited to discuss about our topic today. But before I start with my presentation, I would like to introduce again myself. My name is Alfiani Sabila, usually called Fani. I am a researcher in Indonesian Center for Law and Policy Studies, and my organization, PSHK, is already established and founded in 1998, and we are actively research and doing advocacy about the legal reform, focusing on legislative and also the judiciary. And in the field of legislative, PSHK, my organizations, carries out three main activities, namely legislative monitoring, assessment, and legislative drafting in Indonesia. In the field of judiciary, PSHK is also consistently involved in the reform agenda with the Indonesian Supreme Court. We also actively doing monitoring and conduct research in related with civic space and human rights condition in Indonesia. My organization, PSHK, continuously develops new innovative approaches in legal reform efforts in Indonesia, such as establishing an online legal portal like hukumonline.com in 2000 and pioneering Indonesia Jentera School of Law in 2011. And related to Jentera Law School, I said before, I am also actively involved as a lecture team in that school. And this today, as a brief before, I would like to share our findings about the death penalty and this human rights in Indonesia. I will focus on the findings related to our latest research about the death penalty in Indonesia. So basically, PSHK and Jentera Law School has actively involved to conduct a background study about layered punishment of the death penalty in 2022. This research is conducted as a part of the background study for the implementation of the ratification of the Convention Against Torture in Indonesia. This research is collaborations with the National Commission on Violence Against Women and Cooperation for the Prevention of Torture. This cooperations or collaborations is involving 6 national human rights commission in Indonesia. And this year, we are conducting research on a case study of the death penalty as a form of torture and other cruel, inhuman, and degrading treatment or punishment. And this research is a part of ongoing effort to documented the implementation of 25 of ratification of the Convention Against Torture in Indonesia. This is collaboration also with the 6 Human Rights Commission in Indonesia. In this research, we are go deeper explorations of the hypothesis and initial findings obtained from our background study that conducted in 2022. In this research, we delve deeper how the implementation of the death penalty can be directly and indirectly linked to treatment or punishment that is cruel, inhuman, and degrading. And next slide. Therefore, on this discussion, I will divide my presentation into several parts. I would like to share you about a regulatory landscape of the death penalty in Indonesia, and also how the implementation of the death penalty in Indonesia, its layered punishment and suffering also in the woman on the death row itself. And the third, I would like to share also about the death penalty and the torture and how it linked into the cruel, inhuman, and degrading treatment. Next slide, please. So I'll start with a regulatory landscape first of the death penalty in Indonesia. Yeah. Essentially, the application of the death penalty in Indonesia has been regulated and implemented since the Dutch colonial era. Provisions regarding the death penalty were stipulated in the Wetboek van Strafrecht, or the Dutch Criminal Code of 1918. However, the Netherlands abolished the death penalty in 1870. But meanwhile, the death penalty provisions in Indonesia remain in force until now. Next slide. And sorry, previous one. On my presentation, I show you about at least there is 12 regulations incorporate the death penalty as a form of punishment. I put the diagram, but I think that there's trouble in to showing you in this presentation. There is 12 regulations from the criminal code, military criminal code, narcotics, corruptions, and so on. There is all these regulations are at the level bills. There's also in the emergency law and also at the president decree. And when we view from the content of the 12 regulation itself, content of the laws, the death penalty in Indonesia is regulated in various regulatory sector. It is not limited to the regulations of criminal acts in the criminal code, but also in other laws related to narcotics and even economics. Maybe Hans will go deeper explanation about the criminal code itself in Indonesia. And beyond the multitude of regulations still incorporating the death penalty in Indonesia, its implementation as punishment also inflicts multi-layer impacts. Situation of vulnerability and injustice arise throughout the legal process, even up to the moment of execution. Yeah. And this is show you that the implementation of the death penalty not only inflicts immense suffering on the condemned during the legal process, facing the phenomenon of the death row and ultimately execution. Similar suffering is experienced by those surrounding the condemned, such as family, companions, and even the executors itself. The death penalty not only punishes the condemned, but also inflicts psychological suffering on those around them. And furthermore, in the application of the death penalty, inhuman acts during the legal process are inevitable, including torture and arbitrary treatment by law enforcement officers during arrest, imprisonment, and also for the executions itself. And thirdly, the phenomenon of the death row itself imposed the double punishment on the death row inmates. They must face the uncertainty of when their execution will take place. The news of execution can come at any time without sufficient prior notice. In practice, there are death row inmates who have been confined in death row cells for more than 20 years without certainty of the execution process. For example, the case of Mary Utami in Indonesia, who finally received gracie from Indonesia president in 2022. Sorry, Jasmine, are you raise hand?
Oh.
Oh, okay. Well, I will continue my presentation. So, well, this situation of uncertainty coupled with limited fulfillment of basic rights within prisons, such as inadequate lighting and healthy access, as well as the uncertainty of execution, contributes to the physical and mental suffering of the death row inmates. And the last, the death penalty precluding the possibility of judicial errors. And why? In the context of the legal process, there is always a gray area regarding the construction of facts and actual events. Moreover, there is a long process that the condemned must go through before reaching the courtroom. Arrest and interrogations in many cases are not without the practice of torture and to obtain the confession. A death sentence will clear the door to justice to examine errors in the legal process, both in context of the legal process and also the verdict. Amnesty International data from early 2022 shows that the more than 160 death row inmates in America have been released since 1973 because they were proven innocent or the sentence was deemed disproportionate to their crimes. Next slide. Moreover, I would like to tell you that specificity and vulnerability are also evident as pattern in female death row inmates. The Institutional for Criminal Justice Reform conducted a study in 2022 and on 32 first instance court decision from 202 to 2002 and until 2022. The study found that there are specific vulnerabilities and gender discrimination that occur both before and after criminal sentencing. Generally, women are sentenced to the death for several main reasons. First, the women having a history of being victims of violence. In some cases, female death row inmates commit crimes due to intimidation, threats of violence, or violence from close associates such as their partners. And the second one, being involved in a romantic relationship, which in this situation, there are always a power relation within. And cases with a romantic relationship and power relations background are mostly drug-related crimes. Female death row inmates are driven to commit crimes due to the influence of their partners. And the third one is committing crimes to protect their family from threats by third parties. But unfortunately, not all judges' decision for cases of female death row inmates have a gender perspective and understanding these vulnerabilities of the women. These situations is clearly evident in cases of female death row inmates, both those we interview directly in this study and through secondary sources along we are conducted the research. And next slide. Next, within this part, I would like to begin from the quotes by UN Rapporteur on the torture and other cruel, inhuman, or degrading treatment or punishment, Alice Edwards, and also UN Special Rapporteur on extrajudicial summary or arbitrary executions, Maurice Titball-Binns. They say that the reality remains that in practice, it is almost impossible for states to impose capital punishment while meeting their obligation to respect the human rights of those convicted. And also, they say that the death row phenomenon has long been characterized as a form of inhuman treatment, as has the near total isolation of those convicted of capital crimes and often held in unlawful solitary confinement. Furthermore, increasingly methods of execution have been found to be incompatible with the obligation to refrain from torture and ill treatment for inflicting severe pain and suffering. So, in general, I would like to say that all the suffering and the hardships faced by the people on the death row are seen as violations of human rights. Our research has shown that these individuals, especially women, often endure torture and cruel treatment, particularly while awaiting execution, while they're in the death row. And this prolonged period of uncertainty, known as the death row phenomenon, causes severe physiological distress. Such prolonged mental anguish resulting from the constant threat of death can be considered as form of torture. The UN Special Rapporteur itself has highlighted that the death row phenomenon is a new concept related to torture and cruel treatment. This phenomenon is linked to the severe physical and psychological suffering experienced by the death row inmates due to the uncertainty and anxiety surrounding their impending executions. And also, the Special Rapporteur concludes that the death penalty, including the conditions associated with it, often causes unnecessary pain and suffering, violating international prohibitions against torture and also cruel treatment. Next slide. I think that's all I can share in this forum. It's been pleasure being here, so we can discuss further about the death penalty and human rights in Indonesia, also in Taiwan. And also I wanna tell you that one last thing. We've got some little gifts from Indonesia for you, ACFA participants. There are stickers, booklet, and some handy leaflets about civic space based that conduct based on our research. Just head to the reception desk or ask any committee team to you can tell them to get our merchandise. Thank you so much to all the organizers and also the distinguished participants and also the panelists here. Thank you so much. Giving back to Jasmine. Thank you. Stay safe, everybody.
Yeah. Okay. Thank you. I need to apologize again for my wrong introduction. Yeah, Fanny is from the Indonesian Center for Law and Policy Studies, and she's the researcher of this organization. And then the other organization I mentioned earlier is Contra S. And now the next speaker for this panel, Hans, he's actually the one from Contra S. So let us welcome Hans.
Yeah, thank you, Jasmine. To check, am I audible? Can you hear me? Okay, thank you very much. Thank you, Jasmine, and also Fanny for her great presentations. Let me introduce myself. I am Hans. I am the researcher at the Commissions for the Disappeared and Victims of Violence, or CONTRAS. This is a human rights organization based in Indonesia, specifically in Jakarta. So I will not repeat the legal landscape of death penalty in Indonesia, since Fanny already explained a lot about the legal landscape of death penalty and on what type of crime that regulates and allow death penalty. And also Fanny has also already explained about the impact of death penalty towards the inmates and how at the end we view death penalty as a forms of torture, inhuman, and degrading treatment. My short presentations will be on the number of death row inmates in Indonesia and how that numbers of death row inmates in Indonesian's prison is in line or aligned with the current, let's say, inhuman situations happening in several prisons in Indonesia. And secondly, on how from our study that actually death penalty is not in line with the goal of government in eradicating several types of crimes, like, for example, crimes of narcotics. So to start, based on our documentations, in 2024, currently there are 530 death row inmates all over Indonesian prisons. That is spread across 67 prisons all over Indonesia. So Indonesia is a quite large or big country with 38 provinces, and there are 530 death row inmates located in 67 prison all over Indonesia. Out of those 530 death row inmates, 360 of them, or majority of death row inmates, are those connected or sentenced for drug-related cases. As Fanny already mentioned earlier, that drug-related cases is one of the types of crime that allow a death penalty. So out of those 530 death row inmates all over Indonesia, 360 of them are those sentenced for drug-related cases. This phenomena indicates a phenomenon we call penal populism. Penal populism is a phenomenon where lawmakers believe that death penalty is the most effective forms of punishment in addressing criminal acts. And these phenomena also shows that lawmakers still prioritize a retributive and punitive approach in criminal law. The problem with this phenomenon or this pattern of penal populisms and prioritizing retributive and punitive approach in criminal law is that there are no direct evidence that death penalty, that the approach of retributive and punitive mechanisms that they use correlates with a decrease in the number of drug-related crimes. So even if, the point is that even if currently there are 360 death row inmates connected or sentenced for drug-related cases, but it doesn't show any signs that drug-related cases are decreasing in Indonesia. That shows that actually death penalty is not effective in combating several types of crime, including in Indonesian cases, drug-related cases. Secondly, there is also important that from our monitoring, there beside drug-related cases, many death row inmates are also sentenced for terrorism criminal-related cases. They are being sentenced because they are being indicted as terrorists, for example. The problem is that even if even if they are sentencing many quote unquote terrorists, it doesn't decrease the numbers of terrorist cases happening all over Indonesia. So from this number and also from the portrayal given by Fanny earlier, we can conclude that there are no relations between the decrease on the numbers of criminal related crimes like terrorisms or drug related cases with the numbers of indicted on death penalty, for example. That's first. Secondly, on about the conditions on prisons, for this past 6 months, Contrast has been visiting at least 4 prisons all over Indonesia to look at the situations and the conditions of death row inmates in several prisons in Indonesia. There are several key points that we find. Firstly, we say that there are very limited access of help towards death row inmates in several prisons. This is directly connected to Fanny presentations earlier, in which she says that, there is this inhuman and degrading treatment happening towards the death row inmate. We saw that there is very limited access to health, especially access or, let's say, professionals related to mental health problems. We found that there are several death row inmates that have mental health problems, and there are very limited access given to them. Secondly, there is from our monitoring, we also find that, thirdly, from our monitoring, we also found that there are at least more than 80 foreigners being indicted for death penalty in Indonesia. So out of those 530, there are at least more than 80. From our data, we have recorded 88 foreigners, including citizens from several East Asian countries, including Taiwan. The problem is that there are very less access for them to get a translator when they are defending themselves in the court, or the moment they have been indicted and being put in prison, they have very limited access to translator, meaning that they cannot communicate. They cannot maintain a good communications with their lawyer, for example, or they cannot maintain a communications with the prison guards, for example, and it is hard for them to communicate. So, since there are very limited access to translators, meaning that sometimes it is hard for the prison guards to know or to look after for the need of these prisoners. And meanwhile, they are foreigners. they are far from their family, for example. So that are also the problems that we found in several prisons in related to death row inmates. Lastly, um, from our data and monitoring, since January to September 2024, we found at least there are newly 32 death row indictment. So even if Indonesian prisons currently have 530 death row inmates, Indonesian court and also Indonesian prosecutors still have, an addition towards that number, because this year there are new 32 death row inmates that will be entering prisons in several area in Indonesia. The point is that the number of death row inmate in Indonesia will be spiking up. It will keep coming. And the moment they keep coming, the problem that has been explained by Fanny earlier about the torture and also inhuman and degrading treatment will still happens towards death row inmates, and also still happens in several prisons, meaning that there are a very problematic situations in Indonesians human rights, especially in relations to prisons conditions and also death row inmates. Thank you, Jasmine. Back.
Okay, it's surprising, like for us, for people in Taiwan to know the truth that there are death row inmates in Indonesia and they are Taiwan citizens. Yeah, so it's surprising. Yeah, but we can we can talk later about like the relationship or the correlation between these two areas, these two countries. Okay, so let's welcome Yi Xiang from Taiwan, from TAHR, to share the experience and the situation of death penalty in Taiwan. Okay, Yi Xiang, your turn. Thank you.
Okay. Thank you, Jasmine, and thank you, Finny and Hans. Let us Taiwan people to know more about death penalty situation in Indonesia. Yes. And hi everyone. I hope everyone is safe during the typhoon day. And I'm Yi Xiang from the Taiwan Association for Human Rights. But today I'm here to share this important human rights issue with you on behalf of TAEDP. My English is not good, so if what I share make you unable to understand, it should be my own problem. But I will try my best to share with you my observations on the issue of abolishing of the death penalty in Taiwan, and I hope that friends from Taiwan in the conference room, you can also correct me and make any additions. Yeah. First of all, I want to share with you why I firmly stand on the value position of advocating the abolish of the death penalty. This is not only because I'm a human rights defender, but also because of my master's thesis is mainly about transitional justice. That is to say, when I realized how dictator and its authoritarian system abused power and violated human rights during the authoritarian period, and the death penalty was one of the tools used to prosecute the people and those who resisted. For example, more and more political documents from the White Terror period in Taiwan has been made public. Among them, it can be seen that the judicial verdicts of past political victims clearly record that Chiang Kai-shek, Jiang Jieshi, his will can override the judge's judgment. Originally, the judge only sentenced a prison sentence, but Chiang Kai-shek, he can sentence the death penalty directly. Even though Taiwan formally lifted martial law in July 1987, because Taiwan's transitional justice process involved too many political compromise. It can hard be said that Taiwan has fully promoted or implemented transitional justice, resulting in a lot of injustice transformed into more subtle injustice and are embedded in various systems in Taiwan. This has led to the fact that there are still many remnants of authoritarianism in Taiwan after democratization. The evidence is why many Taiwanese people still defend the Chiang Kai-shek moral code and are unwilling to completely remove the dictator from Taiwan, or why the KMT 国民党 and the Taiwan People's Party, or 台湾民众党, they are close to the CCP, or China Communist Party. They still have key political influence in Taiwan. This proves that the work of transitional justice has failed in Taiwan. And the Taiwan's judicial system and the practice after democratization are, of course, full of tracks of authoritarianism. The best proof of these tracks of authoritarianism is the judicial injustice cases that Taiwan civil society human rights groups have spent a lot of effort to rescue. For example, the Xizhi trial, which is commonly known in Taiwan as Su Jianhe case. And Xu Zhiqiang, Zheng Xingzhe, Xie Zhihong, who are successful exonerated, while Lu Zheng, Jiang Guoqing, and the Du brothers, Du Shi Xiongdi, are wrongfully executed. Currently, we are working to clear the names of Cho He-shun, who has been on death row for 36 years, and Wang Xingfu, the eldest person on death row. In those cases, we can see how the police, prosecutors, and the judges use the thinking and the practicals of the authoritarian period to deal with the victims who were prosecuted by the judicial system. In this sense, I myself do not believe from the bottom of my heart that any kind of justice can be achieved by the death penalty. This was certainly the case during the authoritarian period. In democratized Taiwan, even today, it is certainly not worthy to claim that any execution of the death penalty is justice. And another important context is that my main job when I joined TAR, Taiwan Association for Human Rights, 13 years ago, was to monitor the Taiwan government's implement of ICCPR and the ICESCR from the perspective of civil society. The important significance of this to Taiwan is that Taiwan has long been unable to participate in the United Nations, UN's human rights mechanism. Taiwan also cannot ratify those two covenants. And it is impossible that Taiwan government send a government a delegation to the UN at Geneva to conduct a review of state reports. In order to solve this dilemma, Taiwan's legislator Yuan passed the implementation act in 2009 to turn the ICCPR and the ICSCR into binding domestic law. This implementing act even has an article as a legal basis for the Taiwan government to build the state report reviews mechanism similar to the UN treaty body. In other words, we in Taiwan, we established a national report review system for local review in Taiwan. Also, the scope of ICCPR and the ICSCR covers all basic human rights. My observation is that when Taiwan first implemented ICCPR and the ICSCR, the issue that had the greatest impact was the abolishing of the death penalty. Also, the implementation act of the two covenants and the results of the 3 times state report reviews of did not directly lead to the abolition of the death penalty in Taiwan, but the statistical data shows that after the implementation of the two covenants, the number of people sentenced to death has been decreased. In the past 4 years, there have been no confirmed death sentence or executions. My own observation is that the main reason for the sharp decline in the number of death penalty convictions and executions is the TAEDP, 被死联盟 TAEDP's campaign for the abolition of the death penalty. Their case rescue and the lawyers who define the death penalty inmates, they especially use extensively the human rights provisions of the two commoners during the defense process. This strategy also affects the judges. They need to respond to these UN human rights instruments. And another very important reason is that in recent years, when courts hear death penalties cases, they almost always conduct pre-sentencing social investigations to carefully examine the defendants, their background, and conduct mental or psychologically evaluation. When more and more cases that may have been sentenced to death were later not sentenced to death because of the two commoners. The condition and the threshold for judges to automatically impose the death penalty are going higher and higher. As for the decrease in the number of executions, TAEDP's campaign for the abolition of death penalty and the efforts to use various remedy procedures to prevent the Minister of Justice from signing execution orders are, of course, the main reason. Last month, the ruling of the Constitutional Court decides that the existence of the death penalty is constitutional. This is a disappointing result for TAEDP and the fellow human rights organization in Taiwan. However, this judge limited the application of the death penalty and suggests the prosecutor general shall file extraordinary appeals for the death row presence. It's opened a crack of hope for the prisoners who have been spent an average of 20 years on death row, not knowing when the execution will come. One of the task lines behind for TADP is to organize 37 teams of lawyers to examine the details of each case and find reasons for their legal remedies. This will be another tough battle. From the experience of many other abolitionist countries, we know that abolition of death penalty requires firm political will. At this stage, political lobbying is very difficult in Taiwan. However, we will not give up any opportunity to get through. In addition, communicating with the public and cooperating with the international community are what we will continue to do. The death penalty should not exist in a democratic country that respects human rights. Until the day when the death penalty disappears from this world, we will continue to fight for the abolition. I believe that you and all our partners on the road to abolish it. Okay, thank you, your listening. Thank you.
Okay, thanks for Ishan's sharing. And because we are run out of time, so I guess if Fanny or Hans and you want to like give in some feedback or raise, and it's better, it's much more better if you want to raise more questions. Yeah, and if Ishan want to have some feedback, and then at the end I'll add some points in between. Yeah. Or I can say some information, maybe like I can give you a number. How many Indonesia people working in Taiwan as migrant workers here? The number is 237,000 Indonesian people working in Taiwan now. And that is 1/3 of migrant workers in Taiwan. So we can imagine like maybe unfortunately some of them will face like legal procedures in courts in Taiwan. So here in Taiwan, we have an association of court translator, and they working hard to like to strive and ask for the rights and help those foreigners to facing like legal procedures in courts in Taiwan. But still, there are still many problems in Taiwan's courts. Yeah. So
Yeah. Oh
okay,
yeah, Ishan.
Ishan,
Sorry.
please.
Oh,
Sorry, I'm not sure which one first.
Hans, sorry, and I just thanks Jasmine's told us about Indonesia migrant workers in Taiwan, and because all the migrant workers policy in Taiwan is totally discrimination and a totally human rights violation. So especially our Indonesian friends in Taiwan become migrant workers, almost become domestic worker in employers' house or the distant water fishing vessels. And especially the Indonesian workers in distant water fishing vessels. Yes, because the language barriers. We know some case the employer asks the migrant worker to move some box or something, but they don't know that is a drug or that is the illegal thing. So we know there are some migrant workers are being prosecuted, and they are in the judicial process. But in Taiwan, the drug case will not be sentenced to death penalty. Yes, but and we some human rights organization we are help and monitor this case in Taiwan. Yes, I just make some addition for you. Thank you.
Okay, so thanks for Ishan. Hans, yeah, please, Hans.
Yeah, thank you, Jasmine, for that fact that there are more than 200,000 migrant worker, Indonesian migrant worker in Taiwan. In relations to legal discriminations and even death sentences, it is true that Indonesia has many migrant workers, some of whom who have faced legal discriminations and even facing death sentence in the past in several countries. And while the government of Indonesia was trying to assist them in helping for their legal cases or when they are facing death penalty, for us, it is unfortunate that Indonesia is still having laws still has laws that allow for that penalty, and has even sentenced foreign nationals to give verdict and sentence foreign nationals with death penalty within our territory or within our country, because Indonesian government should understand that maybe our migrant workers in another part of the world also is having, legal discriminations, even facing death sentences, so that it should go reciprocal. If we are helping them and advocating for their rights, we should do the same and not regulate, forms of legal discriminations and also death penalty in our national law. And secondly, if ever not mistaken, our last execution happens back in 2016. And at the time, there are several foreigners that is executed in Indonesia. And that is to show that sometimes the government is not hesitant to, do the executions. But it's been 8 years, and since 2016, yeah, it's been 8 years, and since 2016, there haven't been any executions happening in Indonesia, and we hope at the moment there will be no executions, and we hope also that there will be a reform, because Indonesia has just enact a law, a new criminal bill, a new criminal code that is set to be implemented in 2026. And in that new criminal code, that penalty is not the form of primary punishment anymore. So we are hoping that in the future, the government will move to a more progressive way in, banning the practice of death penalty.
Great. So I want to respond some part of Fanny's talk, like among the 37 death row inmates in Taiwan now, only one of them is a female, and she suffered domestic violence also, and she has some like mental difficulty, and when her case happened. So we just like post a review of research from like Cornell, University of Cornell. They had an overall research to see those death row inmates, especially female death row inmates, what's the gender reasons and happened, and manipulating their cases. Yes, we have a comparison between Taiwan cases and those international cases. Yeah, and yeah, also I want to add maybe the last points, and I hope we like all our organization will have more collaboration afterwards. Yeah, because like there's something big news happened in Taiwan. Like we have a constitutional court that we want to ask the judges to say the death penalty in Taiwan is unconstitutional, so we should abolish it. Yet, but the result is bad, and we failed. And at this case, and at this point, but we still trying. We are still trying another path to abolish in Taiwan. Yeah, but we have a joke in our groups, like our friends will say, yeah, we can retire after this constitutional court. Like if we have a good news, maybe we can retire. But we know it's just a joke, because there are so many other things we need to do now, and also like the correlation and networking in Asia. Like TAEDP, we are also a member of another international organization. I'm not sure if you guys have relation or have any contact with this organization. It's called World Coalition Against the Death Penalty. It's an international organization to promote the abolition of death penalty. Yeah, and actually we get much resources and supports from this World Coalition organization. Yeah, so I think we must share our resources and collaborate more in the future. Yeah. Okay. So
Yeah.
anyone want to share, or maybe that's the last?
Yeah, maybe to close, Jasmine, since you mentioned about your effort in Taiwan Constitutional Court, actually in Indonesia, like 18 to 20 years ago, several civil societies organizations also try a judicial review about death penalty articles to the Constitutional Court. And there was a very quote unquote interesting debate in the Constitutional Court about whether the Constitutional Court um, would like to, take a step in abolishing that penalty, in explicitly says that that penalty is unconstitutional, or to retain that penalty. So it is a debate between abolitionist and retentionist group inside Constitutional Court back at that time. And the context is that there are 9 constitutional judges, 6 of them retain that penalty, and 3 of them agree with civil society saying that that penalty should be abolished because it is unconstitutional. So even if the Constitutional Court of Indonesia at that time decide to retain that penalty in our criminal law, but at least there are 3 constitutional judges who, give a very good argumentations about why Indonesia should abolish that penalty and why that penalty is unconstitutional. This is to show that actually the debate of that penalty is still, let's say, very heated topics even within our national law landscape. And also, I do think that the debate to abolish that penalty will still happens, and we have a very long way to go to to close the presentation. Thank you.
Okay, thank you. So hope to see you guys soon, like virtually or face to face in the future. Yeah, okay. So goodbye, everyone.
Thank
Thank you,
you.
Jasmine.
Thank
Thank you,
you.
Ishang
Thank
and Fanny.
Thank you, Fanny. Thank you.
Bye.
Thanks.
Bye.